tēnā koutou katoa, ko Taranaki te Maunga, ko Aotea te Waka, ko Inaha te Awa, ko Ngāti Runui te Iwi, ko Lynell Tuffery-Huria taku ingoa. Tēnā koutou, tēnā koutou, tēnā koutou katoa. I am here to talk about the WAI262 decision called Aotearoa Tēnei. This is New Zealand. I am going to focus mainly on the intellectual property aspects that are in the report, which is the first 2 chapters for those that have read the report. And Chris mentioned before that I might have to come back and talk about the subsequent section on when the Crown controls Mātauranga Māori, but I'm happy to take any questions about that at the end anyway. So, thank you for coming along this morning. It's great to see you all here. So, what I plan to do today is look at what the report is, provide some brief background to the report, then look at exactly what the report says in the first 2 sections, provide some sort of suggestions on where we might go from there, and then make a quick comparison with what's being proposed overseas in WIPO, and then we'll take the questions at the end. So what is the WAI262 claim? As most of you will know, it is the 262nd claim before the Waitangi Tribunal. It's also had a number of other names. One of them is the intellectual property claim, which is why it has been of interest to me in my profession and our firm. It's also been known as the flora and fauna claim, and I'll give some more details about what that is in a little while. And also Te Ao Māori claim. It's a claim about the Māori world. And again, I'll give some more information about why it's been called that as well. The origins of the claim, one of the origins is that it was looking at, Māori became concerned about the erosion of Mātauranga Māori, so the misuse of Mātauranga Māori. And I'm just going to run through some of the examples that we have seen. So this one here is the use of tā moko on French models, on models for a French magazine. The use of the word Māori on cigarettes in Israel by Philip Morris. Robbie Williams and his moko on his arm. The use of heads in association, or Māori chiefs' heads in association with food. As you may or may not know, the use, a Māori head is considered a tapu item. Food is considered a noa item or not tapu, so it's the complete opposite. So to mix those 2 concepts is actually quite contrary to Māori values in the Māori value system. So that is why that use is particularly offensive. And most recently, some of you may have seen in the papers, a US brewery launched a beer called the Māori King beer, which has since been withdrawn. So these are some of the concerns that led to the filing of the claim. Māori were concerned that, their values were being ignored and things were being misused and misappropriated. Another aspect of the claim, this is a white kumara. It is a kumara that Māori brought to New Zealand when they travelled here on the canoe. These kumara, these kumara were subject to a number of rituals and traditions associated with Māori. And for whatever reason, mostly due to the fact that Māori had, lost land, had land confiscated, this kumara was no longer grown here in New Zealand. But for some reason, government had given away samples of kumara, not just this kumara, but a number of varieties of kumara, to a research institute in Japan. No one consulted with Māori. That decision was made without any consultation with them. And so Māori were very concerned that flora and fauna, native flora and fauna, or flora and fauna that was particularly special to Māori, was just being given away and they weren't being consulted about it. So that's why it's been called the flora and fauna claim. Just to highlight some of how the claim was framed and some of the grievances that were covered in the original claim. What they claimed was that the government failed to actively protect the exercise of tino rangatiratanga, authority and kaitiakitanga guardianship by the claimants over Indigenous flora and fauna, and also over Mātauranga Māori. The government failed to protect the Taonga itself, The government developed policies and practices that overrode Māori right to exercise authority and guardianship over Indigenous flora and fauna and other taonga, including Mātauranga Māori, and also agreed to various international agreements and obligations that affected Indigenous flora and fauna, taonga and Mātauranga Māori, and did not consult with Māori. So the progress of the claim has been very slow, as I'm sure most of you are aware. It was filed in 1991, but I understand that work actually began on the claim in 1988. Hearings completed in 2007, and the report was just handed over in July of this year. So it's been a very long time coming. This is a photo of 90 Mile Beach, which is where, from Ahipara, which is where the decision was handed over. I had the privilege of attending the handover of the report in Ahipara. The reason why they handed the report over there is because that was the home of Sana Murray, who at that time was the only living claimant of the original claim. I'll just acknowledge that Sana has since passed away, so it was very fortunate that she was able to be alive to receive the report. But yeah, it's a wonderful place, and it was a great privilege to be there. There was quite a few politicians that attended the ceremony, and there was about 300 people there in this little marae in the middle of the far north, which was fantastic. So the report, as Chris mentioned, it's 1,000 pages long, so it's a good read, but it's got some key themes which I think are worth repeating here, because they really run right throughout the report and are quite valuable in deciphering some of the recommendations that come out of the report. So the claim is really about recognising Mātauranga Māori. So going back to one of the first slides where I talked about the Te Ao Māori claim, that's what it's really about. It's about recognising the way that Māori view the world, how they hold knowledge, how they value knowledge, and how they look after it and use it. It does attempt to reconcile the Māori value system with the European value system. So it is a report that's really about balancing rights. It's about balancing the Māori right to tino rangatiratanga and kaitiakitanga with the traditional European ownership model. It does not grant tino rangatiratanga over flora and fauna. The reasons for that I'll go into in a little bit more detail further on in the report, but it does grant other rights. It does attempt to create a framework for recognising Māori authority where possible, and at the same time balancing other interests. So going back to balancing the Māori value system with the European value system, it does recognise that there is more than one interest in flora and fauna, in Māori culture in general. And they do stipulate quite clearly that it is not a constitutional review or an attempt to review the place of the treaty in New Zealand's constitutional framework. And that's just, I think, just to make sure that they're not stepping on what might come out in a subsequent report or recommendation from the tribunal at a later date. So some of the areas covered, and these are the 7 chapters that are in the report. So there's the Taonga Works and Intellectual Property section, which is one of the sections I'll go over today. Genetic and biological resources of Taonga species, the relationship with the environment, Taonga and the conservation estate, te reo, when the Crown controls Mātauranga Māori, and rongoa Māori, and international instruments. So it's a fairly wide reaching report, and it covers over 20 government departments and their policies and practices, so it's a significant document. So in chapter 1, the chapter on Taonga Works and Intellectual Property. In this section, the report makes a distinction between Mātauranga Māori, Taonga Works and Taonga derived works. Mātauranga Māori is loosely translated as Māori knowledge, but it also includes how the knowledge is held and valued. So it includes the value system, the underpinning Māori value system. So concepts of tapu and noa are also part of that mātauranga Māori. A Taonga work is an expression of mātauranga Māori. A lot of you will be familiar with the term work in the sense that it refers to a copyright work. So a Taonga work is a copyright work that is an expression of mātauranga Māori. So examples are weaving, carving, koru patterns, those sorts of things. Any waiata, haka, they're all Taonga works. But they must also have some ancestral connection to be considered a Taonga work. So a Taonga work, one of the examples given in the report is the kamate haka. That haka is, obviously, it's an expression of mātauranga Māori, it's a haka. It also has a particular ancestral connection with the Ngāti Toa tribe, and that is pretty well recognised now that that's the case for the haka. The other distinction it makes in the report is a Taonga-derived work, and this is a work that is derived from mātauranga Māori as well, but it doesn't have that ancestral connection. And one of the examples given in the report is the Air New Zealand koru, because that was a work that was commissioned by Air New Zealand. It was designed by one individual in particular for them to use. So that is considered in the report to be a Taonga-derived work. The report held that Māori have a communal responsibility to protect Taonga works and mātauranga Māori. So what the report says there is that Māori, they do have this responsibility to make sure that Taonga works and mātauranga Māori are not used offensively, are not used in a derogatory fashion. So Māori do have this responsibility to stop people from using Māori chiefs' heads in association with food or in association with noa items. And under the Treaty of Waitangi, the report held that the Crown had an obligation to protect that relationship with Taonga works and mātauranga Māori. So the Crown had failed to enable Māori to make make decisions or protect those Taonga works. So that's why all these misuses were occurring, because Māori were unable to have that relationship with their Taonga works, were unable to protect them. In the end, the report said that Māori did not have full ownership of mātauranga Māori, Taonga works or Taonga-derived works, unless they could identify a particular kaitiaki or guardian. So just to refer back to the kamate haka, we can identify Ngāti Toa as a kaitiaki for that particular piece of work. And so in that situation, they should get particular protection. There's not a sort of a general protection granted under the report that Māori get, for mātauranga Māori in general. So what the report does is that it suggests that there be a regime that has two prongs to it. The first prong of the regime is that it allows anyone to raise an objection to a derogatory or offensive use of a Taonga work, a Taonga-derived work, or mātauranga Māori. So it's anybody, anyone in this room could, if they see use of a Māori chief's head on an apple, they could put forward an objection towards this a body, to somebody, whatever body that may be. And at the same time, this regime also has to provide a mechanism for kaitiaki to raise an objection to any commercial use of a Taonga work or mātauranga Māori until consultation and, if necessary, consent is given from the kaitiaki. So, for example, one of the most recent examples I can think of is the use of ka mate on tea towels. That received quite a lot of press. That is a commercial use. That person who put ka mate on the tea towels was intending to sell those and make money out of it, so it was a commercial use. If the haka was considered a Taonga work, then that person would have to get consent from the kaitiaki. In that case, it would be Ngāti Toa. This regime that was proposed in the report, they've actually gone a little bit further and actually suggested a little bit more detail about what the regime might look like. And so what the report recommends is that there be a new commission that is set up to replace the current Māori Advisory Committee under the Trademarks Act. Some of you may be familiar with that committee. It is set up under the Trademarks Act, and what it does is it advises any Māori word or image that appears in a trademark application that is part of a trademark that is filed before the Intellectual Property Office is referred to that committee, and then they advise the Commissioner whether that use is offensive. And that's the limit of their sort of mandate under that Act. So it's very limited. So this new Commission would replace the current regime that we have. And what that Commission would have responsibility for is to hear objections from anyone that considered a use of a Māori, of Taonga Māori, was offensive or derogatory. They would have responsibility for hearing those objections. They would also have responsibility for hearing objections from kaitiaki about commercial uses of Taonga works. The Commission would also make decisions on whether a work was a Taonga work, whether it fell into that category. It would also make decisions on who were the identifiable kaitiaki. The Commission would also be responsible for establishing a register of kaitiaki and Taonga works, and would also produce guidelines and best practices for the use, care, protection and custody of Taonga works, and Taonga Māori as well. So I think that last point is probably one of the most important aspects of this new Commission, because I think that's something that we are really missing now. In Chapter 2 looks at genetic and biological resources of Taonga species. So it's really looking at that part of the, at the start of the presentation I talked about the kumara, so it's really focused on that sort of, those issues that were raised in the original claim. The report held that Taonga species are species that have a special relationship or kinship with a particular tribe or iwi. So a species, it could be the kumara, the example that I gave at the report. In other parts of the country, the tuatara is considered a Taonga species, and there's many others. Māori argue that they have a kaitiaki relationship with these Taonga species. So in the case of kumara, there was a particular tribe that had grown this kumara over time. They were the ones that brought it to New Zealand, and so they did have this. They argue that they had this kaitiaki relationship with that particular species, and the Crown had failed to protect that relationship. The report held that the Crown had an obligation to protect those relationships with those particular Taonga species. But they did not agree that Māori should have full ownership of flora and fauna. Again, this is part of the balancing of Māori interests with other interests. To grant a full ownership of all flora and fauna, the report felt that was not appropriate, and particularly because when Māori arrived here, a lot of the species were already here, so it wasn't something that they had brought with them or something that they had, over time they may have developed a relationship with. There are some examples in the report that talk about while Māori were here, they developed relationships with the environment around them, and they developed kaitiaki interests in certain species, but it doesn't mean that they get full ownership of all the Taonga species, flora and fauna that were here at the time that they arrived. And so that's kind of the rationale that for not granting full ownership of all flora and fauna. So part of the requirement is that Māori have to show this kaitiaki relationship, and they can do that based on through historical accounts, through the usual claim process that we've seen in the past. So some of the specific recommendations in the report, they have recommended a bioprospecting regime that complies with Section 4 of the Conservation Act. So the other recommendations in the report are to promote some of the advisory committees so that they actually become part of the authority. So in this case, they want to promote the role of this pātaka committee from advisory to a joint decision maker, so that Māori get more involved in the actual decision making around flora and fauna. Amendments to the Hazard Substances and New Organisms Act to recognise the kaitiaki relationship. Again, another promotion of an advisory committee so that they actually move up and actually become part of the decision-making process. and this time it's within the URMA regime. And in the patent legislation and PVR legislation, there's quite a number of recommendations. The first one is an amendment to recognise Mātauranga Māori when assessing novelty and inventive step of a patent. One that I do know of is that the sap from a puha plant can be used to remove warts, and so that's pretty a well-known practice that has happened over time. And what the patent law at the moment in our patent law, if I went away and did some tests on the puha plant and identified the active ingredient, extracted it, I could go and get a patent because there's no sort of recognition in our patents law that I can't do that. So this means that now traditional knowledge can become part of that assessment before a patent's filed. It also recommends that under the patents law there's a Māori committee established to advise the Commissioner of Patents and Plant Variety Rights on whether an invention is based on Mātauranga Māori, so the exact example of the puha plant. So if someone did file a patent for that, then it would be refused under this new provision. And whether the invention or PVR is that should be inconsistent with or contrary to tikanga Māori, so inconsistent with Māori practices, so whether it's inconsistent with the tapu and noa concept and other concepts. Also establishes or recommends that there be a requirement that a patent or PVR can be refused if it is contrary to or interferes with the kaitiaki relationship. So really providing much more stronger protection for looking after that kaitiaki relationship than we have at present. Also establishing a register of kaitiaki relationships. Introduce a requirement that a patent or PVR disclose whether it is based on Mātauranga Māori. And also expresses a lot of support for the proposed changes to the Plant Varieties Act. And finally, the report also recommends that each committee prepares ethical guidelines and codes of conduct for use by those in research and development. So what are the implications that come out of the report for users of Māori expressions? It really seeks to acknowledge and recognise the interests of Māori in the use of Mātauranga Māori or Māori culture. So it's really, New Zealand is far more advanced than a lot of other countries in how we recognise Māori culture, and when we use it, we're much more aware of the issues that might arise there. But certainly overseas, it's not the case. If you are planning to use Mātauranga Māori or Māori culture, then the real issue from now on is going to be to consult, get some advice. There are plenty of organisations out there that can help. Implications for the wider community, I think in the future we definitely will see more involvement from Māori in decision making in all aspects throughout the government departments. New Zealand will generally become more culturally aware. I mean, we are fairly culturally aware, but I think there's still a long way to go to understand a lot of the values that underpin Māori culture and recognising them. And this is certainly one of the aspects in the recommendations in the report, and what they see will come from this is a real opportunity for New Zealand to become a leader in recognising cultural intellectual property rights. This is quite a groundbreaking report. It was a groundbreaking claim when it was filed. It was ahead of its time. So it's a real, the fact that it's taken 20 years is quite disappointing because it's kind of put us a little bit on the back foot, but there's still that opportunity there. I'm just going to briefly run through some of the comparison with the WIPO guide and with some of the recommendations. The WIPO has a committee called the Intergovernmental Committee on Genetic Resources, Traditional Knowledge and Traditional Cultural Expressions, which is what TCEs stands for. And this committee has been negotiating for a long time a draft treaty covering the protection of traditional knowledge and traditional cultural expressions, and they've proposed a regime in these as part of these negotiations. Now the regime I'm going to talk about is actually one that came out several years ago, and the discussions have actually moved on quite a bit because they got quite stalled, and they've decided to go from another tack. There was kind of a real split in where the countries were coming from. So, for example, in particular, there was the developed countries on one side and the developing countries on the other side, and both were, they kind of reached a stalemate. No one was moving, and so that's why they've changed tack on this particular regime. But it is quite interesting to make the comparison because some of the recommendations are very similar to what was in the WIPO recommendations. They're not exactly the same, but it does show that given that the WIPO committee has moved on from these recommendations, there is this opportunity for New Zealand to then, say, put forward what the Waitangi Tribunal's come up with, and maybe that can help guide what happens overseas. So just to touch on that opportunity there. So comparing it with the WIPO guide, the objectives in the WIPO guide are very similar to that which is in the report. So it's all about recognising value, promoting respect, preventing misappropriation, empowering communities, promoting legitimate trading activities, and precluding unauthorised intellectual property rights. It protects traditional cultural expressions and expressions of folklore that are products of creative intellectual activity, characteristic of a community's cultural and social identity and heritage. So that's what's in the WIPO guide. In the report that came out from the tribunal, they had a Taonga work, which is an expression of Taonga Māori and has some sort of ancestral connection. So you can see the similarities in the definitions that have been used. Protection measures should be for the benefit of the Indigenous peoples who have responsibility for care and protection, who maintain and use the expression because it is characteristic of their social identity and cultural heritage. So if you compare that to the tribunal's report, the report clearly states that protection measures should only be given to kaitiaki, so the ones that have the particular interest in the Taonga work. Also, recommends that there be established a register of traditional cultural expressions, and our report recommends a register of Taonga works. And for registered TCEs, there's a whole number of benefits that flow from that. The beneficiaries can stop commercial use, require acknowledgement of the source. Again, these are all aspects that have come out in our tribunal report. Require acknowledgement of the source, stop any modification or derogatory use, and stop granting of any intellectual property rights. For non-registered TCEs, beneficiaries must be able to stop commercial use, again, require acknowledgement and stop any modification or derogatory use, and also share in any benefits. There's also, under the WIPO guide, a recognition of secret traditional cultural expressions, so these are ones that no one knows about except for the particular community. There's no real mention of that in the tribunal report, but I think there is scope for recognition of what might be the equivalent of secret TCEs if a particular kaitiaki can show and prove that they have maintained that kind of relationship. So I think that there would be scope under the tribunal's recommendations for some sort of recognition of this. And again, the benefits would be to prevent unauthorised disclosure, use of and acquisition of IP rights. Also, the guidelines require consultation with Indigenous communities. So if you were intending to use a traditional cultural expression or traditional knowledge, you would have to seek their consent. And also allows for negotiations to result in compensation. It also recommends that there be an agency set up, and that agency can be involved in awareness raising, education, advice, monitoring and guidance functions. And they can also become the person that negotiates, or the body that negotiates between someone who wants to use traditional knowledge and the actual traditional community involved. So if you look at the tribunal's report, they've suggested a number of commissions be set up, or two commissions that I've covered today. And that's very similar to this agency role that's proposed in these WIPO recommendations. It also allows for TCEs to develop and change, and I think this is probably something that the tribunal doesn't discuss, whether something could become a Taonga work in the future. There's certainly the possibility that that could happen, but it's not discussed in the report, and perhaps that's something that they could look at, or something that if these recommendations are followed, that they may have to consider in the future. In the WIPO guide, the protections are only granted so long as the criteria continues to be met. There's no similar point made in the report about this, but I think that may be implicit. Certainly if a kaitiaki tried to enforce or stop some sort of commercial use and they couldn't prove they had maintained that relationship, then certainly there would be, there may be some ability to have this requirement that protection only be granted so long as that continued to be met. Also includes a number of details. The WIPO guide is much more detailed. There's sanctions. There's actually some recommendations that there be it become a binding law, and so then it becomes offensive. You can be. It can be an offence, so that's kind of why some of the resistance has come about as well. And just to conclude, certainly you can see there's some similarities between the WIPO guide and what the tribunal has come up with, but there are also some differences, and it will be interesting to see what the government does adopt, whether they actually adopt what's in the WAI262 report or whether they might try and follow what was recommended in WIPO. Until then, I think we have, since the report's come out, I just mentioned before, we'll continue to see some misuse. There's the tāmoko on models that actually came out, I think, the week after the report came out. The use of tuatara as a brand name for a US manufactured car. There was the reaction to the sale of the Māori licence plate, and I see that's just been back on the Trade Me website if anybody wants to buy it for $99,000. There's also a mass overseas production, this was in the paper recently, of cheap Māori souvenirs for sale in New Zealand, particularly during the rugby tournament that's on at the moment. And also I mentioned right at the start the proposed use of Māori King brand on beer. So until these recommendations are adopted, we'll probably continue to see those. So that's my end of my report.